Hello, everyone. James Donnelly, founder and chairman of the CASA Group, coming to you with this edition of the Association Leadership Series. And we have back this month the great Donna DiMaggio Berger, a shareholder at the Becker Law Firm. Donna, welcome back.
Thanks so much for having me back.
I hope you had a good trip. Your partner, though, did a good job for us last month on annual and membership meetings. So you would have been proud of him, Ken Director.
I am always proud of him. I knew he would fill my shoes and then some.
Well, today it's very interesting. After each webinar, we send out a survey and we ask our audience what they want to talk about next. And there was a real interest, Donna, in what my fiduciary responsibility as a board member. And of course, since the legislative session has ended since our last webinar, we've even got kind of some updates to that. So that's what we're going to talk about today. We're going to cover both condo and HOA, a little bit of co-op. And the format is, as always, you guys submitted some great questions, which I've written down to ask Donna. But at any point, you can submit, as Mayor Ness said, through the Q&A. I may not get to them all, but I do read them as we go along. We do post all of these webinars at casagroup.com. This one will be up by the end of the day today. And if you have any questions along the way that are kind of beyond the scope, just send them to info@casagroup.com and we will get back to you. One reminder is that Donna, of course, is an incredible attorney in our industry, but today she's being generous with her talent, but not giving you specifically legal advice. So keep that in mind. And with all the stuff that's going on in our world, I think we're all going to have to get some legal advice on some of this new law. So today, I know there's a lot of interest in some of the legislation that passed. And my partner, Craig Vaughan's going to do a deep dive on April 17th at that webinar into all of the kind of condo HOA co-op related legislative changes. Today, we're going to focus on really the ones that impact fiduciary responsibility. And Donna, I think HB 1203 and 1021, we'll get there in a minute. But I did want to mention the Stoppel bill, Senate Bill 278, which was not going to be good for associations, did fail on the floor on the last day, and that was a good thing. And that was a result of a lot of feedback from board members that called their legislators. So I want to thank you for that. I also want to start by thanking all of you board members. Some of the questions that came in was, all this going on, should I even be a board member? And we hope by the end of the webinar today, we've convinced you that, there's certain things you got to do, but yes, we need you and we appreciate all that you're doing. So I want to just start with poll question number one, Mayor Ness. I always like Donna to know who the audience is. And I know the audience like to know who the audience is. So just if everyone could fill in whether they're representing a condo HOA or co-op. So Donna, lots happened in the last month.
Oh, absolutely. You think the session ended on Friday, the 8th. And I'm so glad you mentioned, James, that we're going to be focusing on board member fiduciary duties with regard to this new legislation, because that's the question we're getting asked all the time, which is, okay, we know there's significant changes for homeowners associations and condominium associations and even cooperatives. What does it mean for me if I'm volunteering to sit on this board? I should mention that these bills have not yet been sent to the governor for action. So he's got 15 days from the date he receives it to either sign the bill, veto the bill, or allow these bills to pass into law without his signature. We don't have any indication, James, that the governor will veto these bills, but I do want to put that out there because historically, association bills go in the last batch of bills sent over to the governor.
I actually have that in my notes that it is subject to the veto, and I was going to ask you. It doesn't strike me as these are in any ways controversial from a governor's perspective, and they will probably pass into law. Okay, Ness, share the results on the poll question. We have more condo people than HOAs today, and I always like to see my co-op show up. So thank you, co-op members. And yeah, let's stop sharing so I can see the questions on the board. There you go. Okay, so Donna, let's frame this. I think the flow that will be best for today for our audience is, what is fiduciary responsibility? Who are my fiduciary responsibilities to? How does that relate specifically to my role as a board member? And then let's go through what the impacts of the most recent legislation are. But what is a fiduciary? What does this mean? I'm a board member. Let's say I'm a new board member. I don't understand what this fiduciary responsibility thing is.
And that's the starting point, that question, James, for the board certification classes we teach is, what does it mean to be a fiduciary? What does it mean to have a fiduciary obligation to your association members? It means you have an obligation to somebody because of the role you're serving. Okay. Officers and directors who agree to serve on boards, they need to put the interest of the association in front of their own interest. That's the bottom line. So when you're making decisions, am I voting in this manner because I'm voting in the best interest of the association, or am I voting in my best interest? They have to discharge their duties in good faith with the care an ordinarily prudent person in a like position and in the best interest of the association. So that's the best way to kind of summarize it. And that obligation is owed to the members of the association.
Yeah, one of the questions we had in the submitted questions, Donna, was, is my fiduciary responsibility to the association or to its members, or both?
Associations comprised of the members. So association is a corporate entity, and the corporate entity is made up of owners. You know, in a cooperative, it's comprised of stockholders, but in a condominium, it's comprised of the members, which are the owners of the association. So it's to both. By the way, you also owe a fiduciary obligation to your fellow directors.
Yeah, and you know, one of the questions that's popped up already today is, does the management company have a fiduciary responsibility? How do you respond to that, Donna?
I believe they do, unless
Yeah.
you very cleverly, James, cut that out of your contracts.
Well, I try to, but you always review my contracts and you don't let me get away with that. So you mentioned with the care of a prudent, ordinary person in like position. And I know when we went through the COVID adjustments that boards and decisions that boards had to make, you mentioned something called the business judgment rule. Is that the same concept as ordinary, prudent person in a similar position?
Exactly. We have 5 decades of case law in the state of Florida that has created, you know, pretty much a litmus test for a court that may be judging the decisions that a volunteer board makes. And if you remember, we've spoken about this. Boards are reluctant to insert themselves into, you know, that decision-making process for boards because they're not there. They don't live in the community. But you still have to exercise the care that a reasonably prudent businessman or businesswoman would exercise. The classic example I always give is that it would not be prudent to hire somebody off the street holding up a sign saying, "I'll work for food," to go do your roof repairs. That is not going to pass the business judgment standard.
Well, Donna, you know, I always like take home value, specific items for our audience to take home. And I think this is the first important one. And I'm hoping by the end of our webinar today, we make our board members comfortable with the duties they have. But if you follow that one rule, you're probably not going to get in trouble. So I'd say that's kind of rule number one, take home number one. Now, you mentioned duties. What are the duties of a board member? Because if I have to do so as a fiduciary, maybe just describe some of those duties that I do have as a board member. Like, do I need to vote?
Absolutely. Show up at the meetings. That's your first obligation. If you ran for the board and you agreed to serve on the board, you have an obligation to show up at the meetings. Now, there are exceptions to this. If you're having a medical emergency, a family emergency, but communicate. You have a duty to communicate with your fellow directors as well. But the first obligation, James, is show up to the meetings. By the way, you are required to cast a vote unless you have a real conflict of interest. A lot of people will say, "I'm abstaining from the vote," because they don't like the motion that's being made. You have to cast a vote, again, unless you have a conflict. Speaking of conflicts, You need to disclose any conflict of interest you may have. If you or a family member or somebody else is involved in a business that is contracting with the association, you need to disclose that conflict. And later we may get into what that looks like in terms of disclosure. You can't commingle funds unless it's for investment purposes. You can't, now this should be an obvious one. Don't accept kickbacks, folks. That will be a breach of your fiduciary duty. And a kickback is, accepting services perhaps from the landscaper, and he'll say, I'll cut your lawn for a reduced price. We're not talking about the little tchotchkes you may pick up at a trade show. We're talking about kickbacks where a vendor is paying you something either in services or in dollars to encourage the board to vote for that contract. Also, don't alter financial records and maintain the physical property.
You mentioned kickbacks, and one of the questions that came in was, can the governing documents of an association be changed to allow that there's compensation for a board member?
The statutes already say that board members serve without compensation unless the bylaws provide otherwise. So I do have a very, very small percentage of clients, but their bylaws do say that the directors can be compensated. This is really true a lot, James, with timeshare associations as well,
Right.
where they compensate those directors. But that's already in the statute. So you can, but it has to be an amendment to your bylaws if it's not in there from inception.
You mentioned the conflict of interest, and it's probably the number one question we got sent in ahead of time. And I think it's a good time to go there because people are so interested in it. So I'm a board member, and here would be 3 or 4 examples, and maybe this will be helpful for our audience. I'm a board member. Can I also be the CAM for the community? Is that a conflict?
If you have a contract with the association, that is going to be a conflict. But people need to understand under the statute, which is 718.3027, conflicts are surmountable. Okay, so you need to disclose it because your board may feel, you know what, James, I know you're on the board, but we really love to still do business. We think you're going to do a great job. Needs to be disclosed. Your management agreement needs to be attached to the meeting agenda. And 2/3 of the directors have to say, we're okay with it. Now, if they say we're not okay with it, you, James, have to write back and say, I'm going to not do this. Okay. Or get off the board, resign. I mean, I will tell you, my recommendation is not to serve on the board at the same time as you are entered into a service contract with the association. The optics aren't great. Remember, these conflicts also involve a director's and officer's spouse, family member. So it's not just the director. What I get asked a lot about, James, is what if I'm a CAM, I'm on the board, but I'm not representing this association? Or what if I'm a real estate agent? I'm not listing units in this building. There are some people who believe that even, for instance, let's take realtors, that sitting on the board may be a conflict for those people because they may want to encourage rentals, wearing their real estate hat, and other people want to discourage rentals. Just being a realtor or a CAM, if you're not doing business inside your particular community, is not a conflict of interest. You may think that person has a certain filter in the way they look at topics that come before the board.
Well, it's funny. One of the questions on the board right now is being a realtor in the building a conflict? And so you explain that, but if I'm a realtor on the board and I'm doing deals in my condo or HOA, but I've disclosed my position, is that acceptable?
So the statute talks about the person doing business with the association. So let's say the association had foreclosed and taken title to a couple units, and then they wanted that board member who was a realtor to list those units. That falls under the purview of 718.3027. That has to be listed, on a meeting agenda. By the way, the owners can cancel that contract if they want, if they don't like that. But let's say that the member is on the board, is a realtor, but is doing individual work with individuals in the community. They're listing individual units. doesn't, in my opinion, fall within 718.3027 because it's not a contract with the association, but I still think it's entirely problematic, and that person should abstain from voting on matters relating, certainly with approvals, with regard to their own units that they're listing.
Yeah, I think there's two levels of conflict, real and perceived. And
Yes.
I think board members need to be aware and sensitive to both of those. I'm just going to segue off because there's a question. What happens is they scroll up and then I leave them, but there's a good one here. I want to, executive positions in our board include president, vice president, secretary, treasurer. Which executive position does the ultimate legal responsibility lie with, Donna?
I love that question because it kind of ties into an urban myth that, some people think that the president has veto power over decisions. Some older documents even state that the president is the chairman or chairwoman of the meeting. At the end of the day, and this really ties into our topic about fiduciary duties and how we can protect boards, even if your document said that you as president are the chairman and you can do this and you can appoint committees and everything you can do, you still need to reach out to counsel. You need to make sure that what the statute is requiring from you complies with what your documents say. And if you're flying solo, you're flying without a safety net. So my answer is every member of the board is equally important. Okay. And if there's a problem, you're all going to be impacted. So if you're sitting on a board and you're really thinking, oh, it's all on the president's shoulders or the treasurer's, that's not the proper mindset.
Okay, good. All right. So you mentioned one of our responsibilities is the physical plant, and there's a lot of questions about the milestone inspections and SIRS, and I think I'm going to leave that until we get to the condo bill. But there's some questions here. Okay, so there is a breach of fiduciary duty. What happens? Who instigates an action, and what would be the action? So I'm a board member. I've violated my fiduciary responsibility. So what happens?
So there's a couple options. You can, if somebody believes there's been a breach of fiduciary duty, my first recommendation is before you leap to lawsuits and complaints with the division, see if you can sit with the board. See if you can. I always advocate communication, right? Sometimes we've got volunteer directors who just don't know any better, okay? And we'll talk about the case law later, because being negligent, even if the action taken is wrong, does not necessarily impute personal liability to that director. We've got a lot of case law in Florida that says if you're a director and you're just negligent or you're just making bad decisions, you're not going to be liable for a breach of fiduciary duty. It needs to rise to a higher level. But if you've tried to communicate, you've attended board meetings, you've sent in letters, and you still say this board is doing some bad stuff, reach out to the division. You can file a complaint. The new laws that we're going to talk about have expanded the division's investigatory power, although they really are triggered, again, by an owner complaint. I think what's going to happen if these bills pass into law, James, is that the division is going to be more receptive. And I know at the end of 1021, which is the Condo 3.0 bill, they talk about the $6+ million that have now been allocated. And I think the 65 or 66 employees who are going to be working on this stuff. So there's going to be some more firepower that the division has to investigate things. So that's one thing. Also, the owners collectively could bring what's called a derivative lawsuit against the director or the association. So that's an option. If you're listening, I'm not advising you how to do this. Please contact your own counsel. But yes, there are various options for you to pursue, starting with an administrative complaint with the division and escalating all the way up to a lawsuit.
You said something there, a lot of times the board member isn't aware, and that's why I'm so grateful. We had 1,000 people registered for today's webinar, and that's 1,000 people that want to be aware. They want to know what their responsibilities are, but ignorance isn't going to help here. It's get as informed as you can. There's one other question about husbands and wives being on a board together. Is that a conflict?
Well, it's not a conflict. In a condominium, it's dictated by the statute. So co-owners of a unit are not supposed to serve on the board simultaneously unless you are a smaller condo. I believe it's 10 units or less. Could be 15, but I think it's 10. And there's no one else to run. Now, sometimes we have husband and wives who own more than one unit. So if they own 2 units, then that's a little bit different. But again,
Okay,
James, optics, you talked about, and you said it beautifully. Real conflict, perceived conflict, but at the end of the day, the power is in the hands of the members, right? You have an option not to vote for spouses if you see their names on the ballot.
yes, the one thing we all get to do as owners is to vote, and if we don't, shame on us. Okay, one more thing. I do want to ask you, there are some are called Gold Star cases that are out there that have really been decided on and helpful in directing this conversation. But what about my responsibility as a board member to comply with state statutes? And we're about to get into that. Like how do I even know how to comply with state statutes?
Well,
And is that a duty? Is that a duty?
well, it's absolutely a duty, because if you don't know what the law says, you're probably more likely to violate it. Okay. And now we've got specific language regarding deadlines for milestone inspections and deadlines to have a structural integrity reserve study completed that clearly says if you don't do this, you're in breach of your fiduciary duty. So that's number one. You need to know about it. And like you said, having people on webinars, but the new laws require mandatory education. So in the past, it was you could attend a course, or you could sign a statutory form which says you've read and understand and agree to uphold the governing documents. I've always said myself that if we had somebody on a witness stand or in a room and we were deposing them, I really wonder how many really read, understood those documents, because they're pretty hard for most people to understand. But now there's going to be mandatory education requirements, 4-hour certification class and 1 hour annually for condominium directors of continuing education to serve on board.
And that's for all the board members, president, vice president, doesn't matter. It's all board members have to do that.
All board members. And I know there may be some directors listening to us right now, kind of saying, oh my God, but it's your safety net. You want to make sure you understand what your obligations are under these laws. So I think it's a good thing to have education about what's going on.
One of the questions we have is, what if one board member unilaterally, makes a decision or does an expense, does something, what do the other board members do if one board member isn't acting under their fiduciary responsibilities?
So there is a parent authority, there's a parent authority, and then there's actual authority to act on behalf of the association. Okay. I'm the landscaper. I go to you, James. You're not even an officer on the board, but you're a director. And you say, we want you to do X, Y, and Z. I give you a contract, you sign it. I have no reason to know, James, that you are not an officer and you do not have the authority to bind the association to this contract. That's a parent authority. Actual authority is the board has met, and this is within the scope of your authority. You have been designated as the person who will sign contracts. What I like to tell clients is this: if you have somebody who's gone rogue and has signed a contract, if it's parent authority and the contractor or the third party didn't know and shouldn't have known, then you're bound. You're kind of stuck. But one of the things you can do is pass a resolution that clearly defines who can bind the association to the contract. So you let your list of contractors know these are the people that you should be talking to with regard to our contracts, and no one else on.
Okay. And one of the questions is reporting to the division for condos, HOAs, and co-ops. All of them can report a breach of fiduciary to the DBPR.
Yep. Yeah, and they've expanded the DBPR's authority when it comes to HOAs. Traditionally, The division has not really gotten into it because they haven't had the funding or the manpower. We're moving in a direction where the division will probably eventually be doing everything in terms of oversight of HOAs that they do for condos and co-ops.
Okay. So you mentioned Gold Star cases, and in our prior conversations, you referenced two kind of seminal cases that really helped define board responsibility. Maybe just speak to that to give our audience context.
Sure. So there were two cases that you and I previously discussed. One was the Perlow v. Goldberg case. That was a third DCA case. It dealt with a claim with a director who failed to renew the fire insurance on the clubhouse. That's pretty significant. He didn't want to renew the fire insurance and something bad happened. Anyhow, the fourth DCA did not hold that director personally liable. The court held that directors are not personally liable for negligent actions, even if such actions were clearly wrong. The other case that you and I talked about is a fifth DCA case, Sunny Boy. And in that, the plaintiff alleged that the condo directors failed to maintain and repair the common elements, and Sunny Boy was leasing out a unit. So Sunny Boy claimed that you, board, because you didn't maintain the common elements, I couldn't lease out my unit. So that impacted me. Again, the court found that the court held that unless there's a basis for fraud, self-dealing, or unjust enrichment, the directors could not be held personally liable. But I want to give you an example of a case where the board members were held personally liable, and that was in the B&J Holding Corp v. Weiss, also a third DCA case. For those of you who don't know, that's down here in South Florida. The condo directors appointed by the developer were held individually liable for the failure to collect maintenance payments as required by law on unsold units. And the court basically found that these directors had breached their fiduciary duty because their actions were deliberate. So they're working for the developer, and they said, we're not going to charge these units, they haven't been sold yet. Why? Because that would be good for the developer. So they put their interests in front of the best interest of the association members. That's what we said at the start. If you really want to ask yourself, as a director, am I doing the right thing? You've got to ask yourself that question. Am I acting in the best interest of the association members or in my best interest? One other textbook example of breach of fiduciary duty. Years ago, we had a director in a case. He gave himself a 99-year long-term lease to preferred parking spaces. We see that with storage lockers. We see that with boat slips. So we've even seen some directors colonize the common elements by punching out the walls of their unit and taking over a few feet of the common corridor. Those are textbook cases of breach of fiduciary duty. But from what I said on the other cases, again, the court is not automatically going to go after a director personally if the mistake was negligence or they didn't know better. I will say one other thing. If you as a board are acting against a vice of counsel, so this is the Berg v. Bridle Path case. If you ask and say, can we specially assess for this? And your counsel says, you cannot specially assess for this. And you go ahead and specially assess and lien and attempt to foreclose, you're going to have a problem. That's another example of breach of fiduciary duty.
Okay. I get so excited, Don, I forget about my poll questions. Can you, Ness, put up poll question 2? Because one of the things that we recommend is that they actually have a conflict of interest policy in the association. But I'm curious to know, now that we've already told our audience what about conflicts of interest, what they are. The other thing, while that is going through, though, I have some people on from Texas, and we're going to do a separate Texas webinar, and I'm not asking you this question, but I do want to respond. The concept of fiduciary is not just a Florida thing. It's a universal thing. We are talking of specific Florida legislation next. So I would ask my Texas audience we'll do a separate one for Texas, but also I still think this is relevant because a lot of it is just general principle rather than Florida specific. Okay, let's share those results, and I want to keep moving So, Donna, there were two bills passed. Well, I'll call them the HOA bill and the condo bill. Let's go HOA first. Often we go condo first here. HB 1203. I kind of call it the hammocks bill. You know, there was that huge fraud case at the hammocks HOA in Miami, and a lot of this law was designed around responding to that case. I will tell you, you were in Tallahassee, I was in Tallahassee. We worked hard at getting this law relevant and executable. And if you saw the first version of these bills, it was terrible. And I'm personally still not happy with some of the things that got through, but I'm happy we were able to take out most of the bad stuff. But maybe just start on the HOA side for our audience. What was in 1203 and what does it mean to me as a board member and specifically my fiduciary responsibility?
Right, and you made a great point. I just want to reiterate it, that the final bill, I know CAI had gotten out a bill and people were looking at the not final version. The final version, which I think is 39 pages, is better. There are some challenging things here, but that's why we're here to talk about it and teach people, you know, what operational changes they need to implement to be able to incorporate these changes and still be able to fulfill their fiduciary obligation. So this was sponsored by Senator Bradley. A couple different things. They have actually defined, James, what a CAM's role is. So I think people need to look at their management agreements, right? Because now it's requiring CAMs to attend in person at least one membership or board meeting of the HOA annually, provide to the HOA members the name and contact info for each CAM or management company, list the manager's hours of availability and a summary of the duties. They have to post this information about the manager on the association website. And if there's any changes, so let's say a manager gets swapped out, somebody changes, you got 14 business days after that change to update it. We talked about the continuing education. Directors and, well, CAMs must now also complete at least 5 hours of continuing education, which pertains to specifically to HOA, 3 hours of which must relate to record keeping, and there's a reason for that. The official records must be maintained for 7 years unless the governing documents require a longer time. They have changed the requirements regarding website, and now they reference not just a website, James, under this bill, they reference a mobile app, okay? Any association that has 100 or more parcels, they have by January 1st, 2025 to upload certain governing documents. We don't need to get into all of that. I know that Craig's going to take a deeper dive into that bill. Membership meetings require 14 days notice, advance notice. That's a little different because in some governing documents it's 10 or maybe fewer. So this is now requiring 14 days notice, posted in plain view on the homepage. And was any document to be considered and voted on by the members during the meeting or any document listed on the meeting agenda has to also be posted. Let me keep going through because there's a lot here, and stop me at any time if there's a question.
Let me ask you a couple questions. First of all, your firm and other of the major firms in our industry, you'll actually be distributing summaries of these bills. So if for our audience, don't worry if you're not writing this down. None of these laws will become effective till July 1. Is that correct, Donna?
1203, yes, it has a July 1st effective date.
But I want to ask you, I have a few questions here on the educational requirements. We already defined that all board members must do it. But when do I have to do that by under this law?
I will need to get to that section. So hold that question when we go through it.
No problem.
So I'm sorry, go ahead.
Well, the other thing I want to mention on the website, in fact, I wanted to put up poll question 3 while we're discussing this, Ness. The websites are really interesting. So now condo and HOA have to have the website, have to put up the information, and it's obviously from a management company's point of view, it's really important. But one of the things I want to mention, especially for our self-managed communities, Donna, You just listed a whole bunch of changes that the CAM or, well, the board's responsible for, but the CAM has to do as well. I think we literally have to, each of our communities, obviously, if you have a management company, we are literally having a session, and I'm sure my competitors are as well. Okay, what do we have to change operationally to comply with this new law? And there's a lot, including the websites. And you brought up, what if management companies change and there's a time gap between the information up because the websites change. These are all things we're going to have to work through.
There's a real possibility that if you're transitioning from one management company to another, and you're using a management company's webpage as your website, that there could be a gap of a few days or maybe even a few weeks where your resident complainer files a complaint against the division saying they don't have a compliant website because you're in the midst of a transition. Again, something that you need to consider when you're entering into a management agreement. You really need help with that. The law also requires something new, James, because they really have come down hard with regard to document inspections. Most of the complaints that these legislators have fielded have been, I can't get my association documents. The board or somebody's keeping them from me. So the new law requires the association to adopt written rules regarding methods of storing official records. So there's going to be I know there's a lot of associations. I may be jumping the gun because I think you have a poll question related to document inspection rule.
Yeah, well, you know what, Ness, share the results of 3. It's really great to see that our communities are aware of the website responsibility. And obviously, if you have a management company, it's our responsibility to get that up there for you. But also, I have, let's put up poll question 4, because I think it would be helpful for our boards to hear about, Donna, the responsibility we have. This is, even as a management company, it's a complaint. I'm not getting my information fast enough, or you haven't given me exactly what I want. So what is our responsibility as a board member to provide requested information? Donna.
So you have 10 business days to do it, and there's a change somewhere else, but we'll talk about that in a minute. Any director or board member or manager who knowingly, willfully, and repeatedly violates the document inspection process with the intent of causing harm to the association or one or more of its members commits a misdemeanor of the 2nd degree. The term repeatedly means 2 or more violations within a 12-month period. Now, for those of you listening, you may have people who dash off records inspection requests every month, maybe a few times a month. So that is a problem. There are criminal penalties for defacing or destroying accounting records. That's a misdemeanor of the 1st degree. And if you refuse, any person who willfully or knowingly refuses to release documents because they know those documents will reveal that they have committed a crime, that's a felony of the 3rd degree.
Wow. Well, look at, so is your recommendation, I'm sharing the results of whether our audience have document inspection protocols in place. And I'm happy to see 40% do, and I'm sure a lot of the I don't knows do as well. But can we still put together a policy in our association that says, as an example, an owner can only request them once a month? Is that protocol still compliant with this new law?
So as of right now, the division hasn't passed any corollary rules regarding these laws, because remember, these laws have not yet they've not yet passed the governor's desk.
True.
But assuming that, then yeah, I would get with council. We have fairly robust document inspection rules. We like to think they're reasonable. Look, these are the owner's documents. They're entitled to see them, except for those documents that are considered confidential and privileged. Attorney-client work product, personal identifying information about the owners or applicants to reside in the community. So there is a framework in place, but get with council because you will need to have this kind of policy. The new laws also require that the association provide a checklist of what they're giving you. And if the association does provide that checklist, it creates a rebuttable presumption that the association has complied with the document inspection process. Let me circle back to that other question. on when you have to complete the education. It was always now it's within 90 days after being elected or appointed to the board. That was always the case. But the change is it went from within 90 days of being appointed or elected to the board, you could submit the statutory form or completion of a course. Now you have to complete a course. And the other change, James, is that 4 hours annually of continuing education for directors. But that's in 1201. I'm kind of bleeding back and forth between 1021, between 1203 and 1021.
Well, you know what? I appreciate you very much because I know this is literally, these are hundreds of pages of statute that you're trying to read, digest, and have on the top of your head. Okay, let's flip to the condo 3.0 bill, I think they called it, the Lopez bill, House Bill 1021. What's in that our audience needs to know, and how does it affect our fiduciary responsibility?
The first thing I would say about this bill, and I know a lot of clients have had an issue with this, is that if a manager or management company fails to return the requested association documents, it creates a rebuttable presumption that the CAM or the management firm willfully failed to comply. It could result in the suspension of the professional license for either the CAM or the management company, and a civil penalty of $1,000 per day up to 10 days. So that's pretty huge. There is some overlap between these two bills. This one delves into what the CAM's responsibilities are. To your point about being self-managed, there's a lot of stuff that has to get done in these communities. So if you're not managed, you're doing this on your own. A big one was hurricane protection. So Condo 3.0, Vicki Lopez's bill, actually defines what hurricane protection is. We didn't have that in the statute before. So now it's defined as hurricane shutters, impact glass, code compliant windows or doors, and other code compliant hurricane protection products. That's going to be interesting. I just had a meeting last night with a client where they're deciding whether or not to take a membership vote. They're a 300 unit building, and 100 units still don't have any form of hurricane protection. So this was going to be interesting. Of course, they've got the criminal penalties in here for kickbacks, which is a felony of the 3rd degree. And this is a very interesting one. Upon receipt of a complaint from an owner, I would guess, the division shall monitor an association for compliance with the insurance provisions of the statute and may issue fines and penalties established by the division for failure of an association to maintain the required insurance policy or fidelity bond. So that's different. And that, again, underscores how the legislature has wanted to really amplify the division's role here. So if somebody complains to the division and says, we don't have proper D&O coverage, we don't have proper fidelity bonds, I have a question about the way it's drafted as to whether or not that includes we don't have proper windstorm coverage. Because a lot of clients have been asking, given the insurance crisis, can we self-insure? So this
is saying no. This is saying no, isn't it?
Well, it says, on the one hand, it says insurance provisions of the statute, but then it says that the division may impose fines and penalties for failure of association to maintain the required insurance policy or fidelity bond. It's talking about directors and officers. So I do have a question about how expansive they're going to be when applying that.
Okay. I wanted to ask you, I saw a question here on the board that I have lost. All right. Oh, here we go. Go down a bit. So are the document requests from an owner, do they have to be in writing?
Yes. An email counts as writing. There is a language. There is language in 1021, James, that now also adds that the association's official records have to be maintained in an organized manner. So if you call somebody in and say, fine, you want to inspect the documents, come in, we'll see you on Tuesday at 9 o'clock, and then you direct them to a junk drawer or just boxes filled willy-nilly with stuff, that's going to be a problem. So now they are requiring, I'm assuming people complained to their legislators that when they went to a document inspection appointment, they couldn't find anything because everything was disorganized.
So, but now I have to put half the records on the website. If I have an owner that says I want to see X and X is on the website, can I just say, go to the website?
You can say, go to the website if you've got everything on the website, which
Yeah,
most
okay,
people
good.
don't.
Yeah, I know. Well, that's going to be increasing. But again, you had mentioned it's going to be imperative on us as associations to respond to these information requests, with the checklist, with a, irrefutable act that we did in fact deliver it. These are all procedural changes that have got us excited over here on the management side.
And if you've got everything on the website and the website goes down and you can't meet the deadline to produce it, you're going to have a problem. So I think you need both. You need to organize your physical documents and get everything digitized and uploaded to a website.
Okay, I want to get, I promised our audience that we would end this with how do we protect ourselves from all of these obligations we have, fiduciary responsibilities. But I do want to talk about, and maybe let's put up question 5, Ness. So we've had so many webinars on the new milestone inspections, all the laws that resulted from Surfside. And the purpose of today is not to do a deep dive into that, but there are 2 elements I think we need to discuss. One is it's certainly an additional fiduciary responsibility. And 2, I think we're going to have a lot more cash sitting there waiting to keep our building maintained. So number 1, is compliance with the milestone inspections and related funding a fiduciary responsibility? And should we be relooking at our fidelity bonding given this new funding requirement? So
yes and
thoughts.
Yes and yes. So the statute clearly provides and has provided since SB 4D 2 sessions ago that it is a fiduciary obligation of the directors to make sure they meet these deadlines. 12/31, the end of this year, 12/31/24 to get that SIRS done. Same thing for the milestone inspection, depending on the age of your of your building. Okay, and it says right in the statute, if you don't meet these deadlines, it's a breach of fiduciary duty. In terms of fidelity insurance, remember, fidelity bonding, any budget adopted after the end of this year is going to, if it's a threshold building, 3 stories or higher, is going to be required to fund for structural integrity components. Floors, the roof. Oh, we've got our, well, yes, so we've only got 45% who have looked at it.
Yeah, and I think the I don't knows could be a non-board member, but I honestly, we put this in here because we really wanted to reinforce, when you're thinking now about what do you need to do as this unbelievably volunteer board member to make sure you're good. We started kind of with the reasonable person business judgment. That's step 1. Step 2 is have management or legal advice. In fact, Donna, you said something to me earlier today about if you have a great reserve study person, a great engineer, and a great lawyer, and a great management company, those acts in themselves would be evidence of taking care of your fiduciary responsibility. Do you want to expand on that?
I call them safety nets of sort. I want to go back to the analogy of somebody up on the trapeze, the high trapeze. You're up there solo without that safety net, the risks are much higher. So you have management professionals, you have an engineer that you're relying on for your milestone inspection. You have to, that you can't do alone. You have a reserve company doing the SIRS. In the past, people were doing, a lot of communities were doing their own reserve studies. The professional advisors are your safety nets. And also pick up the phone and call. If the question is there liability? If that's a legal question. For fidelity bonding, I just want to say, because the budgets passed after this end of this year for buildings 3 stories or higher are going to have a lot more in reserves, if you don't increase your fidelity bonding, and those bonds should cover all available funds. So think about that. Let's say you're going from 100,000 in your reserve account. Now you've got 500,000 or more. You need to contact your insurance agent and make sure you've increased your fidelity bonding. You're also going to want to make sure that you have proper directors and officers coverage in place. And you may even want gap legal insurance coverage for other issues.
Yeah, let me reinforce. I love these take-home values. So number one, please, audience, have your insurance agent and your management company, or who's ever doing your books, make sure your Fidelity is updated. Your Fidelity insurance. Two, D&O. Let's make sure that's in place. Current. It is a great comfort to have that. And the third one was these safety net experts. They're experts because we as board members aren't necessarily experts in all of this. Okay, so those are all seem to be good things. What about, it sounds to me like I'm an association. I'm actually going to have to change some of my practices and my protocols. Does it include, do I need to change my documents to comply with any of these law changes? Because that would seem to me to be a fiduciary responsibility.
Absolutely. I'm so glad I had just written down the word amendments on my notepad right here. You like asked the perfect question. Well, listen, let's talk about 1203, which is the HOA bill, what you refer to as a hammocks bill. That has a July 1st effective date. That bill severely restricts an HOA's ability to restrict commercial vehicles, to restrict other exterior changes to the residences. And most people living in HOAs expect their association to be enforcing those kind of restrictions. So it's going to be terribly important to get with council if you want to restrict certain things to get those passed before this bill takes effect. To your other point, you may have conflicting things when it comes to notice requirements, when it comes to your budget. I can think of a host of things that are going to need to be changed in your documents, and I'll tell you why. Because boards change hands, new boards get in, and what do? They look at the documents and they go, oh, we can do this. They don't necessarily want to pick up the phone and call me or other attorneys because what do? We actually charge for our advice. That you need your documents to be an accurate guidebook, an accurate operational guidebook. So I do think our phones are going to be ringing off the hook for amendments and protocols. And just like the mandatory protocol on storing documents, I'm recommending a comprehensive document inspection rule. So everybody, you create the framework, a board member code of conduct. In a board member code of conduct, it outlines what everybody should be doing and how you have to disclose conflicts of interest. I don't know that every time, James, you want to pick up the phone and call the attorney and go, what do we need to do? Sit down, get with the attorney, and get all of these policies and protocols and amendments fleshed out. Doesn't mean you're never going to have to call us, but it's going to go a long way towards making directors feel a lot more comfortable with these changes.
Next month, Don, it'll be 4 years since you and I started doing these webinars. And I think every moment of time since has been a recommendation to our audience. If you haven't reviewed your documents and done, I like the idea of doing one comprehensive amendment to kind of capture all of the changes since. And I'm not a big fan of some of the laws that are about to get signed by the governor, but it is what it is, and we have to comply. So I think more than any point in the 4 years, it's time to have these documents reviewed and make sure they're supportive of current legislation. We have so in terms of what can we do, risk mitigation. We talked about the general reasonableness test, the business judgment, Fidelity insurance update, D&O insurance update. Hiring professionals where necessary, and updating our documents. Is there anything else, because it's 12:56, that we've missed in terms of some advice, some guidance for our audience on what we can do to make sure we're good as in our volunteer role?
I can't say this strongly enough. Please contact your legislators. If you're serving on a board, you know how difficult this is. James just mentioned about amendments. I talked about amendments. A lot of communities can't amend their documents because they cannot reach the amendatory threshold. The members won't approve it. There are things in here that are very burdensome to association operations. That doesn't mean this is the last say. Laws change as we see. Please reach out to your legislators, come up with some, inform them of what it means to serve on a board. Hopefully next year we can have another bill, and maybe we can have language in there that makes it easier for associations to amend their documents to incorporate these kind of changes each year. That would be helpful.
Well, I'm glad you brought that up because we actually have reached out to our clients this year in asking them to reach out to legislators. And, as a management, we don't want to bother our boards doing tasks, but you are so powerful. I mean, our 50,000 associations in Florida and a little less of that in Texas, if you look at the population, it's like 10 million people. We can 100% influence legislators with our votes. So when we make those asks, it's for good reason. I think the last thing, we talked about it a couple webinars ago, this Corporate Transparency Act, but I have some questions on the board, about now I got to disclose more information. And I know it has been challenged, constitutionally challenged recently, but what do we do as board members right now as it relates to the Corporate Transparency Act?
Well, there is a deadline. What you need to do right now is speak to your association counsel about whether or not you need to be filling this out now. But, look, it remains to be seen. Yes, it was challenged. It was Northern District of Alabama. There was a stay imposed. The government is going to appeal, and their position is that stay only applies to the plaintiffs in that case. So I know if you're taking a loan, for instance, that the banks are requiring this information to report in connection with loans. I don't think it's necessarily a reason to panic. A lot of the information is already public record, okay? And we all trust the government, don't we, to handle our sensitive information?
I can't end on that. I want to end this way, Donna. First of all, I started this webinar by thanking you, our audience, for doing what you do. It's incredible. And I hope we've given you some comfort today that following some reasonable steps with the guidance of your professionals, I encourage you to stay the course and help guide your communities through these times. I think there's great strategies that Donna has shared with us to make sure that we're not at risk as board members. But Donna, this was a great topic. I've got 48 unanswered questions on the Q&A, and I apologize that, but this is how relevant and interesting and concerning it is to our audience. So Donna, this has been great. I really think you've captured the essence of fiduciary responsibility. And I know our audience is grateful for that. So thank you.
It was my pleasure. Thanks for having me. Thanks, everybody.
Okay, everybody. So Donna and our information is on the board. April 17th, my partner Craig Vaughan's going to a webinar to do a deep dive on this legislation. But we're so grateful for what you do. Thanks for joining us today. Thank you, Donna. And we'll see everybody next month. Have a great day.